this video, we look at refusal or inability to work. If you have a genuine need to self-isolate or are living with someone who is particularly vulnerable, you should convey this to your employer as soon as possible. NHS staff should receive their full normal pay whilst in self-isolation. This is what they would have otherwise earned if they were not in isolation. This would also include any enhancements. To be eligible for statutory sick pay, the employees do not have to be personally unwell. If they choose to stay at home because of the increased risk to them from coronavirus, they will still be eligible for statutory sick pay. Pregnant employees or other vulnerable groups may also be protected by Equality Act 2010 against discrimination. This would also include protection against any disciplinary action or dismissal. You may refuse to work if you genuinely believe that you are at serious risk of harm. You are entitled not to return to work until that source of harm is removed from your workplace or appropriate mitigation measures have been taken when employees refuse to return to work. Some employees may express particular concerns about returning to workplace. This may be traveling on public transport, caring responsibilities, or because of their own vulnerability, for example, pregnancy, or where they are at increased risk of contracting illnesses. This will likely to be an issue only for those who are required to work on site. Anyone working from home is unlikely to face these issues. The refusal can also be because of the employer's inadequate measures at workplace. The employee may feel insecure about attending the workplace. How can employers deal with such a situation? The employers should clarify the employee's concerns and make notes of any meetings they hold. This also goes for the employees to make sure that accurate records are kept of what was discussed. The employers can ask the employees what steps they can reasonably take. ACAS also recommends that an employer should listen to any concerns staff may have and carefully consider the individual's personal circumstances while treating requests consistently. The employer may consider following steps. Number 1, can the employee be given separate area to work? This can help reduce the risk. Number 2, can the start time or end time of the employee's shifts can be changed, which has been in practice. This may assist the employees to travel at times when it is not busy. So staggered start and end time. Number 3, can the employees be allowed to utilize their annual leave for a certain period of time? The employers cannot dismiss the employees simply because there might be issues in dealing with the employee's safe return to work. Any such dismissal can be construed as unfair dismissal depending upon the circumstances, and there may be a lot of explaining to do at the employment tribunals. Accordingly, any disciplinary action or withholding pay on these bases may result in the employee resigning and claiming constructive unfair dismissal, in particular where the employee is vulnerable. This may also result in discrimination claims or even whistleblowing claims. Employees with disabilities may need reasonable adjustments to their working place or practices in some way. The employees and/or the union representatives should be involved in any such decision-making process. Employers will also have to be mindful of another type of discrimination, discrimination by association. This takes place where the employee suffers some kind of detriment because they live with a disabled person. Employers should further note that the employees in certain circumstances do not have to have 2 years of service to claim unfair dismissal. They can claim automatic unfair dismissal for which there is no minimum qualifying period. In the current circumstances, they can raise issues in relation to health and safety. Health and safety related dismissals may be automatic unfair dismissals. The employee's belief might well be reasonable where the employer's management of an existing infection or contamination has been poor, or because colleagues are not following recommended hygiene or social distancing guidelines. The extent to which the employer has complied with government guidance and clearly communicated this to the individual will be relevant, but not necessarily determinative of whether a fear of danger is deemed reasonable. Employers should note that employees who complain about the safety of the working environment may also have protection from detriment and dismissal as a whistleblower and may be able to claim interim relief. Where interim relief is granted, this means being on full pay until the case is decided, which may mean employer paying the employee for many months without the employee having to come to work. The employers should further note that even if the employee loses case at the end, any payments made will be non-refundable. In the next section, we will briefly look at changes to the employment terms, and then we will move on to redundancy dismissals, layoffs, and other short-time working measures. See you in our next videos.